as well. I have a question right here that's titled "Right to Demand Psychological Testing." This particular question states that he moved back into town where his children live, and since moving back, his ex-wife has done everything to isolate him from his children, denying him his visitation. And he also states that there may be some psychological issues that prevent her from co-parenting. And he states that the only reason that she has custody is because she moved out of town, out of state, and the transition would have been difficult for the children. This question is more of a two-part question, and the first part dealing with access to your children and being denied visitation. My first question would be, what does the parenting plan state, if there is a parenting plan that was entered? You indicated that your ex-wife has custody. Even if she has sole custody, that doesn't deny you from visitation. If you've been able to see your children on extended weekends, holidays, summers, and things like that, then there's a parenting plan in place which you are allowed visitation. If she's not allowing the visitation that has been implemented by the court, then she's in violation of a court order. And your remedy to seek with the court is what's called a motion to cite for contempt. Basically, what that alleges is you have a court order. Both you and your ex-wife are ordered to abide by this order, and she has not. Therefore, your legal remedy is to seek a motion for contempt. It's sort of a mini trial. It won't take as long or extensive as your divorce trial. Sometimes it could take at the most a day, half a day. And it's a hearing in front of the judge. Usually the judge that you're divorced in front of, unless that judge has left the bench and there's a different division, then your case is reassigned out. And what you do is present evidence on the fact that you have been denied this visitation pursuant to the court order that is currently in effect. Before you go ahead and file this, I would recommend that you send either an email or certified letters so you can have a paper trail of the fact that you're requesting and she's denying. That will only help further bolster your case and the evidence that you'll be able to present at trial. The second part of the question deals with psychological issues. You would have to go in on a motion to modify the custody arrangement. You can't just come back into town and state, well, I think my ex-wife has some psychological issues and that might prevent her from being able to co-parent. If you think that there are some psychological issues dealing with your ex-wife's ability to co-parent and properly function as a mother to these children, then I would file what's called a motion to modify. And what you would do is file that motion to modify, as identified earlier, for the motion for contempt in the same division that you were divorced in, unless that judge has left the bench, then your case would be reassigned out. And in that motion to modify, one of the allegations you want to allege in your motion to modify is the fact that mom has certain psychological issues, which are whatever that you may deem them to be, X, Y, and Z, which prevent you from being able to properly co-parent as a mother for your children. And if there's any other issues that may come into play regarding her ability to parent, or how she disciplines, or the fact maybe that she moves around a lot, or that your children are not doing well in school, or there's some abuse, whether it be physical, mental, or sexual, or that mom is unfit or unstable, I would allege it in the motion as well. And once you file that, you go ahead and draft what's called a motion for psychological counseling or testing, and then in the motion you allege, it'd be similar to the allegation that you allege in your motion to modify, but this would be limited to what you think that the psychological issues are. And then you call that up for hearing, and then it's presented to the judge. It's a non-testimonial motion here in the state of Missouri, back in chambers. It's your lawyer, and if your ex-wife has a lawyer, he or she will be in chambers as well. Now, the judge may elect to do this on the bench if your ex-wife chooses not to employ a lawyer to represent her, and she represents herself pro se, then this will be done on the record out in open court from the judge ruling from the bench. Usually when you're in chambers talking with the judge regarding your motion for psychological testing, the court sometimes may order both parties to submit to a psychological test, each party to pay for their own. If the other side does not request one, the court's not going to automatically grant one as of right. And if that's the case, and it's just your motion that's pending before the court, then you may be required or obligated to pay for the testing, for the psychological testing of your ex-wife. In that same motion, you're going to identify a psychologist or a psychiatrist that you want your ex-wife to be analyzed by, and I'd give the name, the dates that they're available, and the times that they're available. So then the court can order that that party submit to a psychological testing on one of those dates and times. And also in the same question, it indicates that you would like for your children to attend counseling. Is this something that you can assist on, especially since they're on your insurance? If you're going to want your children to attend to get some counseling, you're going to have to allege some type of abuse or neglect by mom. I wouldn't just go ahead and file a motion with the court for psychological testing of your children unless they exude or exhibit certain behaviors which would put one on notice as something maybe going on that needs to be looked into further. If that's the case, you may want to file what's called a motion for a guardian ad litem and have a guardian ad litem appointed in your case. That guardian ad litem will represent the best interests of your child or children. Then he or she can make a recommendation if they think that this child needs counseling. You can still go ahead and file a motion for counseling once you would get that guardian involved, or if there's other issues that have gone on, I would identify those in your motion for psychological testing for your children. We've got another ask a lawyer question here that states that this person is representing himself in a divorce in Florida. What does he need to bring with him to trial? Each of us has a child in our custody and will most likely stay this way, although probably disputed. Well, first of all, I'm licensed in Missouri, and in Florida, not really sure what the laws would be, if they would differentiate or they would be they are similar to the state of Missouri. But if that were the case here, the first thing that sticks out and there's a red flag here is the word disputed. If you're going to go into a contested hearing, I would advise you getting a lawyer to represent you. You don't want to lose your property interest, but most importantly, the interest of your children. You've got to think in the big picture, and the fact that what is the best interest of my children, especially if you think there's going to be a dispute. You may also want to file a motion for a guardian ad litem, which I talked about earlier. It's not granted automatically, but if there's going to be if custody is going to be contested, or you think it may be contested, it may be in your best interest to have a guardian appointed so that he or she can represent your children. And if that's the case, then he or she will interview you, will interview mom, will speak with your children depending upon their age, and come up with what they think should be a parenting plan and recommend that to the court. Now, just because a guardian is involved and recommends a parenting plan to the court, that doesn't automatically mean that the judge is going to rubber stamp that. You will have your opportunity to examine the report and ask the guardian ad litem questions. Now, however, if there is allegations of abuse or neglect, then the court must appoint a guardian ad litem. Now, there are fees associated with this cost of having a guardian ad litem appointed to represent the best interests of your children. And a lot of times what the judge will do is allocate that proportionally to the incomes of each party. So depending upon what your total income is divided by what you make, you may be on the hook for that percentage of the guardian ad litem fees. If the hearing is going to be uncontested and you're representing yourself pro se, I would bring to court a list of the property that you have acquired during the marriage, a list of the property that would be your separate property. And separate property would be anything that's given to you by bequest, devise, inheritance, or a gift, and identify that out separately and ask the court to award that to you. I would put what you think is a value on the property that you have acquired during the marriage. A lot of times people will put what they pay for it. I would go ahead and take in consideration that there's depreciation on the property that you have acquired during the marriage and not put the price on it that you paid for it. And then I'd come with a list of what you want and a list of what you would be willing to give to your wife, and then submit that as an exhibit. I would also come with a draft of a parenting plan, and if you're in St. Louis County, go ahead and access that online, St. Louis City, I believe, and also you can get that at all the courthouses in the state of Missouri. You can get what's a general parenting plan. You can tailor that to your case, so that then the court can award the parenting plan from what you prepared. And in the parenting plans, it deals with visitation, when holidays, it deals with summer vacation, school vacation. If you want to do every other weekend, nights during the school year, I mean, you can really tailor to whatever is best suited for